Okay, is it proper that for unit trusts such as Amanah Saham Bumi Putra only allow hibah rather than nominee?
Okay, I answer this in terms of the law of the land. Maknanya this ESB already dia dah apa ni iktiraf hibah amanah to be part of apa ni untuk distribution of the ESB lah. Jadi I think is proper or not have to you Harun have to take over because hibah amanah already apa ni some of the I think Muslim scholars in Malaysia or some of the officers Sharia scholars in Malaysia already agreed that hibah amanah can be done for ESB. Itu yang I tahu lah. Yep.
So from Sharia perspective, Hibah is the mechanism that Muslim can do during his lifetime. So in this case, the asset is unit trust. So unit trust, like Brother Khairuddin has mentioned, unit trust, unlike CPF or insurance, unit trust is considered like a personal asset. So with personal assets, you need to be very clear what you want to do with that personal asset. So in this case, then there is no other instrument to show or to declare that you want to give during your lifetime except for Hibah. So that is why I think ASP, they implement this Hibah instrument so that the Hibah instrument will be clear for the family members as well as for the beneficiaries to know, oh, so the declaration has been made, I will give Hibah to ASB during lifetime, and everything is very clear. So there is a sirah, means there is a pronouncement, and there is also a kabul, acceptance that, okay, I accept that this Hibah has been given to ASB. And the beneficiaries also has to accept during lifetime. So it becomes very clear. When this thing is properly done, it will be transferred to ASB when someone pass away. And ASB as a trustee, they will actually now have the mandate, okay, because they are the trustee, right? And they follow the trust, and the trust did mention that, okay, this thing has been given to this person, and in the trust that ASB has to give to the beneficiaries. So there is no more faraidh distribution there because during lifetime everything has been given via hibah.
Yeah, I want to add in. I think this policy, this scheme by ASB is a good scheme in the sense that it's for easier estate administration. Yeah, because I think in Malaysia there's no for nomination. It's not quite different from Singapore, where the nomination is, you know, the one who receive the nominee is 100% is a hibah to the nominee. But Malaysia wise, I think insurance nomination is a trustee concept. So I think when hibah amanah was introduced for ASB holders, I think it's a good way for estate administration. So you can decide during your lifetime who want to give for your asset. So it involves a bit estate planning. So sometimes you have few assets under you. So if ASB is part of your estate, so you can distribute early. Yeah, you can estate plan early.
Okay, let's move on to the next question. Does wills of our assets overtake faraidh?
That's a very good question. Does wills of our assets overtake faraidh? So when someone do wills, especially in Singapore, we tend to think like a conventional will, meaning it's like a non-Muslim will. Because for non-Muslim will, once you have done, you have appointed someone to become your educators, a trustee, and you can actually mention clearly the specific gifts you want to give. So there's no more intestacy. Okay, for Muslim is faraid. But we cannot think in this way because there are differences between conventional will, and Islamic will. Okay, so for Islamic will, what happened is that they actually interact between each other with between the Islamic inheritance law, which is faraid, and also will. So for faraid, is the default distribution for Muslim for the final stage. Okay, and Faraid mentioned clearly that if you want to give, there is a provision of 1/3 that you can give when you pass on. So it's actually Faraid that spell out clearly that if a Muslim wants to give via will writing, they can give, but this give must be up to 1/3. Yeah, so that's the first difference between conventional will and Muslim will. The second difference is that this 1/3 that you want to give is meant for non-faraid beneficiaries. So who are your faraid beneficiaries? These are your parents, biological children, and also spouse. Yeah. So when Muslim wants to will away, they cannot will away to these person or these beneficiaries, because that family members, that beneficiaries has been taken care of by Faraid. Okay, so Faraid allow you to give 1/3, but to other people than these Faraid beneficiaries. So you can give to adoptive parents, adopted children, your nephew, relative, friends, charitable bodies, and that's where we have wakaf and so on, and even educators. Yeah, so I think that's all from me.
Yeah. I think I just if I want to on it to get along was about, yeah, a lot of people mistaken wasiat with will. Okay, in terms, and we are governed by AMLA Act, as Harun mentioned earlier. The only difference is that because we are governed by AMLA Act, and then the conventional side we have a Will Act. So I think, Harun, do you want to mention about the difference in terms of the witness, in terms of AMLA Act and the Will Act, about the
Yes.
executors role?
Yes. Thank you so much for that. So for Muslim, when they want to do an Islamic will writing, the Wills Act actually mentioned that you need two witnesses. Okay, so as their provision is that as long as these two witnesses are not the beneficiaries of your will, then you can actually do it. So there's no requirement that it has to be male or female and so on. But from Sharia perspective, the witness has to be two male or four female witnesses. Yeah. But then because we are living in this country and then we are governed by Wills Act, and therefore the Wills Act mentioned that as long as you have two witnesses, be it male or female, then that will be actually validated in the court. The court will just take that as a valid will. Yeah. So since we are in Singapore, then we are governed by this Wills Act. Therefore, we our if to be safe, then we can take two male witnesses. Means that we cover both the Wills Act and also the Sharia law. But if let's say one has done will and this will has a two witnesses which are a combine of male and female, for example, then it still be valid in Singapore court.
Okay, thanks for the insightful reply. We shall move on to the next question.
Sure.
I understand cost that one cannot use own insurance proceeds to pay fidyah, zakat, and badal hajj in event of one's death. Why so?
Right. Okay. So maybe I can take this question. So when it comes to doing fidyah, zakat, and badal hajj, all these are obligations upon Muslim and Muslimah during his lifetime. So this should come from halal income and halal instruments. Okay. So the reason that maybe you are advised by someone that you cannot use the own insurance proceed. This is because the insurance proceed may be actually from conventional instruments. Yeah, and but again, okay, let me just explain first. So from conventional insurance, the contract is non-compliant from the Sharia perspective. Therefore, because the contract is non-compliant, that whatever derive from that contract is also non-compliant. Therefore, you cannot pay something non-compliant, non-halal to pay your obligations or even a deceased obligation and so on. So that is why, if you ask me the reason, it cannot be channeled in this way. So everything must be halal for Allah to accept our deeds. Yeah. Having said that, we need to be aware that insurance is a matter of differences of opinion among scholars. Yeah. So, for example, if I can expand this topic, for group insurance, okay, those group insurance that the company pay for their employer, for their employee, for example. So this kind of group insurance sometimes is the benefit when they work with that company. So they don't pay the group insurance. Yeah. So is the company who pay the group insurance, all the premium and so on. So there's a group of scholars mentioned that if let's say it's kind of benefit that you as a worker enjoy while you are working, and then you pass on, and therefore the group insurance is activated. There's an insurance proceed. Therefore, the insurance proceed from this group insurance, because you don't pay the premium, is a company who pay the premium. Therefore, it's considered as a gift. If this is the case, then you can actually use the group insurance proceed to pay fidyah, zakat, and badal haji. But as a general rule, I would say that all conventional insurance, in our opinion, is non-compliant because of the contract, not because of the concept of insurance. We are not against, Islam is not against a concept of insurance. It's against how the contract is formed and so on, and how the interest that is generated behind some of the life policies or life insurance. Yeah.
Okay. Harun, can I see it uh, due to, because let's say the insurance policy been nominated to a certain nominee, so can it be seen that way also, because that nominee received the insurance proceed actually is not part of the deceased estate, so cannot use to pay the fidyah, zakat and badal haji.
Right. I think that's another dimension that Khairuddin bring up, which is actually very good. Suppose that insurance contract or that insurance proceed coming from a nomination, meaning that the deceased has nominated a person, a beneficiary to receive this. So by right, there is no inheritance discussion here, because technically the money is not going to the faraidh doesn't apply in these insurance monies, and so we belong to the beneficiaries or the nominee that has been named inside that insurance nomination. Yeah. So maybe that could be another reason why it's not an obligation for the beneficiaries to pay the fidyah, zakat, and badal haji. Okay, when it's due to the deceased person, so it has to be taken from the inheritance estate money itself, and not from the insurance. Can be from this way also.
Yeah.
Okay, thanks for the reply. We shall head on to the next question. My siblings have agreed to split our mom's assets equally instead of distributing according to faraid. Is it fine to do so?
Inshallah, I think this intention is very good. The siblings have agreed to sit down together and to actually distribute according to faraid. It's a matter of when does this agreement take place. Is it before mom pass away or after mom's pass away? Okay, if the before death, then whatever that you agree, it can be done. Okay, but it's something that it has no effect yet, because in Singapore, when you don't do any plan giving, no estate planning and so on, and the matter goes into faraid, the siblings will receive first the money, the faraid money. Then after that, when they receive, they can sit down together and then forego their rights and split accordingly or equally, right? So you need to understand that before death, you can agree on. In fact, that you can actually make some family deed of arrangement that we have in Singapore. It's a black and white saying that I will forego my rights, I want to split this equally and so on. Yeah, but this contract is not airtight as per se, like someone can actually back up after a person pass away and so on. So that's my understanding of this question.
Okay. From my understanding, Harun, I think it's best the contract or the family deed is done after somebody pass away. Let's say you want to split equally, so have a black and white. Yeah, and then one more thing is that I think to agree to split is okay because Sharia court in Malaysia also they ask you, because it's based on my personal experience when we need to meet a Sharia court in Selangor to ascertain to the judge we are the beneficiaries of my late mother's estate, because he's a Singapore PR with Malaysian IC. So the Sharia court itself will ask whether you want to go for faraid or go split among yourself. So I think that means to show that it's fine to split the deceased asset equally if agreeable among the beneficiaries. Yep.
Okay, thanks for the reply. Let's head on to the next question. What should I do with the inherited CPF money from my deceased family member? Am I allowed to invest that money, or should I donate it to others?
So this is a matter of understanding when it comes to CPF money lah. So when you receive CPF money via CPF nomination, therefore that money will be considered as a gift from a deceased family member to you, and now it belongs to you, and you can actually do whatever you want with the money. You can invest, you can give back to the family members, you can donate, and so on. Okay, but if you receive the money from meaning there is no CPF nomination, meaning that you receive by the way of faraid from the public trustee. Okay, so this kind of money, then before you invest or donate to others, you just need to check whether the deceased has debts, whether the deceased has fidyah, like the one that we discussed just now, or unpaid zakat or hajj badal. Then after that, when you receive, after you have minus this thing off, and whatever left is for you to actually use it. So the only difference is that the first one, straight away you can use it without any consideration because it's not faraid or inheritance money. The second one is inheritance money, therefore there's a step for you to consider first before you use your own money.
I have nothing to add. Only thing is that based on Insurance Act, I think pre 2007, those nominated insurance policy, that means those nominee receive the money is act as a trustee based on previous fatwa, right, Harun? And then
Yeah.
after that, they review the fatwa, and then now those nominated beneficiaries that receive the nominated money from the disease are considered as a hibah. That's why I want to add. So actually, it's a gift from your loved ones. That means already during lifetime they already agree upon your loved ones that you want to give the insurance proceeds from CPF or insurance to you, to the nominated beneficiary. Yeah.
Okay. Okay, the next question looks like a carryover from the earlier question on CPF. And since it talks about riba, we shall combine it with another question. Okay, so the first part would be, do we need to cleanse riba? And then should we cleanse off riba portion of a inheritance first, then contribute to zakat, distribute to the remaining, or we should distribute first?
Yeah, thank you so much, Zul. This is a very interesting question, and as you can see that when we talk about CPF, right, a lot of things can be discussed because CPF money is sometimes you don't see it right now, but when someone pass on, then the CPF money can be a lot as well. So let me summarize first the issue here. When it comes to riba from CPF funds, yeah. So there are two scholarly views in Singapore. The first view mentioned that the interest that is generated from our CPF account, whether CPF OA 2.5 or 4% CPF SA or even retirement account later on, all these are not riba, okay, the interest money that you receive every year. So these are considered as a gift from government to its citizen, because when government set up the CPF account and when they actually invest the money, they don't require the money. They just actually park the money, and then because of the accounting purposes, therefore that 2.5% or 4% is just a gift from a government. That's one point of view from scholars. The other point of view thinks that the contract, when the money been placed inside CPF account, the contract is you are actually lending money to the government, right? Even though the government says that we don't require CPF, Singapore government says that we don't require this lending from the citizen. Okay, we just want to make sure for retirement. But the contract itself is very, very so-called like, that's why you get 2.5. If not, then there's no entitlement for you to get. And then their argument is that even if, let's say, you pay house for your house installment, then when you want to sell the house, you need to put back whatever interest that has been accrued. So there's like a very binding obligation kind of things. So the contract is interest from this point of view. Yeah. And at the same time, so when they invest money, assuming that they get 10%, is obligation. So it becomes like an obligation for the government to pay 2.5 or 4%. So because of that, then the contract itself is considered riba. So if you belong to the first group, let me answer for both of the questions, Zul. The first group, then you don't have to cleanse the money because it's considered as a gift, hadiah, and therefore everything that you have, you don't have to cleanse. And if you belong to the first group of opinion, then you don't have to cleanse, then contribute zakat if there is unpaid zakat, and then the remaining you can give to faraidh. Okay, if you belong to the second group, which FIWA, I myself representing FIWA and Khairuddin as well, we think that CPF money is interest. And therefore, what happened is that the treatment is like this. The capital, the contribution over the years that you have done is yours. Okay, the excess, which is the interest itself, which is whether 2.5 or 4%, yeah, all these are considered interest money first. But when upon retirement, upon 65, 70, you may not have a source of income anymore. So based on this view, if you are in need of that excess money, the interest that has been accrued over the years, you can utilize the money based on the principle of hajj or darurah. Yeah. And if that's the case, then the second question will be, do you need to cleanse? Yes, you need to cleanse it if you don't need it, if you have other source of income. But if you don't need it, then you need to cleanse first the money, and then only start to pay unpaid zakat. and distribute the remaining to faraidh. So it really depends on how you want, how convinced you are whether to follow the first group of scholars or the second group of scholars.
So what was the cleansing cleansing ratio percentage? 5%, right? The cleansing
Uh,
percentage.
Yeah, so if you can if you have the second view, then you need to understand that it's 2.5% for the CPF OE and 4% for the CPF SA lah. Okay, I think you just do the estimation over how many years, and then that's the money that you need to cleanse if you are not in need of the money. But I believe most of us, when we reach the retirement age, our situation is not doesn't permit us not to use the money, and therefore, from the sharer perspective, is halal if it is in need for you to use the money, and inshallah, you don't have to cleanse the CPF account.
Okay, thanks Ustaz. Such a detailed reply we have there. Okay, the next question is pretty similar to what we have asked just now, but it's of a slightly different vein. So this time round, the question is: I heard from an ustaz that assets are best to be distributed on a compassionate basis. Should the situation deems faraid as less compassionate? What's your opinion?
So, compassionate basis means ihsan, right?
Ihsan, yeah.
Yeah, ihsan, yeah. So, I mean, yeah, the opinion of the ustad who give you the advice is correct, because in the event that, okay, when, for example, let us be upfront here. So most of the time, the issue is that not that the female inheritors not happy receiving less or receiving slightly lesser than the male inheritors. It's just that sometimes the male inheritors doesn't carry his responsibilities. Yeah. So if that's the case, then what happened is that if you can sense that my family composition doesn't allow the responsibility, or you can sense that responsibility won't be carried out. So if that's the case, then you can actually plan your estate distribution. Okay, there will be a family that have a very strong understanding of religion. So they know that when they receive the faraid money, it's not for them to just spend on for their own expenses and so on. It's actually a responsibility. It's an expected responsibility for the male inheritors to take care of the female inheritors. Because when female inheritors receive their money, the faraid money, they don't have to spend on the family members, for the mother, for the parents, or for the kids, and so on. But when the male inheritors receive the money, they have to actually spend. It is expected, it's an obligation for them to spend. Okay, so some really understand this situation. That is why I have some stories where the male inheritors, upon receiving faraid money, they actually return back or foregoing their rights to the faraid beneficiaries, other faraid beneficiaries, because they understand if they receive the money, they have to be responsible to take care of the welfare of the other faraid beneficiaries. So some of it actually forego their rights. Some of them actually understand the family members are not able to handle the money. Therefore, they take the money, but they take care of their family members. If you can sense that this is not the case, then that is why I think Fatwa Muiz has issued that if you think that you need to plan, better to plan during your lifetime. Don't wait until the faraid distribution.
So in essence,
Okay.
faraid carries responsibility towards the family.
That's right. That's right.
Yeah. Can I add in start?
Yeah, sure.
Yeah, my opinion is that because it's case to case basis for each family. Each family structure is different.
That's
So I
right.
think I ever touch this on my presentation. Don't know whether can share or not. Okay, not. Okay, my presentation whether it's about equality and equity. Equality is giving people the same thing, but equity is fairness in every situation.
Mm.
So that means I think Allah knows best about our life, about our character. So sometimes certain family is best to distribute it evenly, but sometimes certain family is how you plan your estate. Some get lesser, some get more, because of you, as Ustaz mentioned earlier, responsibility. Some male are responsible enough to take care of maybe the younger family members, or the female beneficiaries. So it depends on each family structure. So I wouldn't say, because it's like trying to say Faraid is, I mean, Faraid itself deemed by already dalam surah Al-Quran is not, we try to what, to go away Faraid. Yeah, so there's a certain family issues that can be resolved through Faraid itself. Yeah, that's what I'm trying to say. So it depends on case by case basis. Yeah,
Okay.
on
Yeah,
the family structure.
okay, such a detailed answer there from Ustaz and Brother Kai, which has coincidentally answered the next question in our queue. Hence, we'll move on to the following question. Okay, in Malaysia, widows and children have been left homeless because their houses have to be sold to pay the inheritance to uncles. What's your comment on this?
So this is the example where male inheritors didn't understand the whole spirit of Faraid. Yeah. So by right, when he is eligible, uncle is considered like a very a second layer of inheritors. Okay. So by right, you have fathers or you have brothers to take care, but maybe this person are no longer around. So when uncles by right, when they receive the money, they have to take care what, and they shouldn't force their rights to the widows and children. So in this instance, that is why we have all the necessary tools before we reach to that stage. Okay, that stage when if this is a situation, the uncles will be answerable in front of Allah when they receive the money and they force the widows and children to be left homeless. Yeah, because by right, when he received the money, when they receive the money, they should actually prioritize the welfare of the widows and the children, not the other way around to pay their credit card expenses or their loans and so on. Yeah, because it's something given by Allah to them. They don't work on it, okay? Because their family members pass away, Allah has appointed them to take care, to be closer to the widows and the children. So in this case, that is why we have to understand that faraid is a last distribution that Allah decide who will actually receive it. Yeah. So before we reach to that stage, the deceased should actually plan. If he or she sense that the family members is not the one who are responsible and doesn't take care of the family members.
Yep. I agree with Ustaz Harun. I think nothing else to add more on that.
Yeah.
Yeah.
Okay, thanks for that reply. Okay, seems we have another Faraid question. How do we know if someone need to do Faraid or not? I know that certain circumstances doesn't need for someone to do Faraid. What's your take on this?
Hmm. If I can think about this question, okay. So this question is about whether we need to do faraid or not. Okay. So you need to understand one situation is that in Singapore, when someone pass on, the default distribution is faraid. Okay, we Muslim are governed by this AMLA,
AMLA.
Administration of Muslim Law Act. Yeah, so all these things will be distributed according to Faraid, unless during your lifetime you have planned it otherwise. Okay, so when you plan otherwise, then that's where you have sense that okay, I need to give more to my spouse, for example, to take care, to make sure that my children will grow up, have a good education, can pay their tuition fees and so on. Yeah. So if you have that kind of situation, you need to plan in advance, and that is where. So the matter of whether you need to do faraid or not doesn't come here actually. So if you have done it well, Faraid allow you to plan from the very beginning. Yeah, our religion allow you to plan, advanced planning, and so on. And that's why we have wakaf, for example. So wakaf, if Muslim only has to do faraid, then wakaf is a beautiful concept, is a philanthropic concept that faraid allow you to give during your lifetime. If you have mentioned that you want to do wakaf, you can do wakaf to, for example, welfare, charitable bodies. You can also do wakaf to your family members. Okay, you set aside a property or a shares, and then that shares is properly done. Every year, when that shares generate income, your family members will receive it. There is no discussion on Faraid anymore because Faraid allow wakaf from the very beginning. So this is our successful stories of Muslim in the past when they understand what is Faraid actually. So Faraid is the last stage when okay, there's a personal asset, there's something that I just want to make sure that my family members benefit it, and I surrender to Allah's will, and I follow what Allah has ordained in His book and so on.
Yeah. I'm not too sure, Ustaz Arun, but whether this question is asking about whether need to do doesn't need to do faraid for certain circumstances. That means based on the family structure, the simplest family structure I can think of is actually all male, so based on your family ring of hairs.
Mm.
Is it the all male? Let's say a husband pass away, leaving a wife with no parents, if all male. That's what I see. Yeah, maybe if talk about Farid. Even then is there's a Farid, right? Distribution.
Yeah,
Correct?
that will be the default. Even if you have sons or multiple sons, there will still be a Faraid distribution. Yeah.
Yeah. So there's no, I mean, there's no comprehensive, there's no Farid distribution. Okay, never mind.
Okay. Thanks for the reply once again. I would say I gained some new knowledge along the way. Thanks for that.
We learn
Okay.
together too. Yeah.
Okay. 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 We shall move on to the next question. This is about will. Is the 1/3 for every person or 1/3 divided by the number of people in the will?
Right. So the simple answer will be as long as your asset when you pass on is not more than 1/3, in percentage is 33.33%, then you are allowed to will away to the number of people. Okay, so it's not one. I mean, you can spell out 1/3 for every person as long as this 1/3 doesn't go beyond the 33.33%.
33%. No.
So that's the
Yeah.
so-called one ceiling, right, or cap.
Mm.
Should the money, say for example, you will away 50,000, then this 50,000 is actually more than the 33.33%. The court will
Mm.
actually say that you need to reduce that 50,000 to be equivalent to
33.33%.
33.33%. There's no issue actually for Muslim. Muslim is easier when it comes to faraid distribution compared to other kind of distribution in this world.
Yeah, I want to add in also. So normally for me, when I advise my client to do wasiat, I always tell them that you want to do the 1/3 is best you based on percentage, 5% or 1% or 2% to your non-waris or your non-beneficiaries. So easier because at the end, because when we want, because we won't know until the end of our life what our net asset. But actually, by right, you have to calculate our net asset. You see, in terms of estate planning. But that's a rough estimation. So if you put an absolute amount, it will be deemed quite difficult for the trustee or the executor who want to execute your estate. So the best is still percentage wise. Let's say your net asset value after paying off zakat, after paying off the badal haji is about, let's say, 100,000. So if 5% usually calculated for the executor. If absolute amount, you have to make sure that 10,000 or 20,000 is not more than 33%. So that's about one third lah. So
That's
normally
more.
a lot of client want to give away their one third to charity. So I told them easier is 5, 10 or 15, not more than 30%. Yeah, I want to add in that one.
Yes.
Thanks so much, Faraid.
So the gist is for will to structure a will, it's better to give in percentage rather than absolute number. Am I right?
Yeah,
Yeah.
yes. Yeah, I
Okay.
got one. Yeah, a very good example. I got one case, I think few years back. This pakcik got sons, got daughters, got wives. So in terms of faraid, already settled who, but he want to give to his siblings, and siblings he considered non-waris. So he want to give absolute amount. So I told him very difficult for executor. Let's say you put absolute amount. So after that, he decided that he won't put a percentage. So percentage is better. He want like to give like 10,000 for his sibling, but he got 8 or 9 siblings. So end up can be 90,000. So my worry is that let's say he pass away, his estate is less. When he give 90,000 absolute amount to his siblings, it can be more than 33%. That's the risk. So that's why he cannot do absolute amounts. Better put a percentage wise.
Okay, understood. Thanks for the reply. Okay, we shall move on to the next question. How do you calculate one's a deceased debt to God?
This is
Right, I think we have discussed this in terms of the items.
Yeah.
So these are unpaid zakat for that particular year or the year when he missed or she missed the zakat. Fidyah,
Fidyah.
that is if you miss fasting intentionally or unintentionally. Okay, unintentionally when you fall ill or whatsoever. Intentionally, maybe during your younger times, you are more so-called like trying a lot of other things. So now you have realized that you need to pay your fasting and you have missed that period. Therefore, there's a fidyah and badal haji. Okay, so how we calculate it? Of course, we need to sit down and understand how many years that he missed. For example, the fasting days and months. For zakat, we need to understand whether he has properties, whether he has investment, insurance also have a zakat portion that you need to pay and so on. So when it comes to calculation, I think it's better that we sit down and then we understand. But these are the three items at least we need to be aware of lah. Unpaid zakat, fidyah, and also haji badal if he has or she has not done the hajj.
okay. I think I don't answer already. Okay.
Okay. Let's move on to the next question. What if the deceased are profound dead, such as he got the plane that he is in got lost, and for a few years, but after that few years, he was eventually found out, and he is still alive. So what happens in that situation?
Not sure this is a true story or fiction.
I think it's a figment of one's imagination.
Yeah. So
Yeah, I think based on the movie, what movie is that? The
lost is it? If I
no, the one who got the ball and then make a ball his friend in a standard
uh,
in island. I forgot already. Aye.
when it comes, then you can tell us, Khairudin. So when it comes to this, right, what happened is that when someone is profound dead, okay, but you couldn't locate him or her, so there is no closure yet. So in Singapore, we have a system that you need to wait for 7 years.
7 years, right?
7 years. That's right, good. So you need to wait for 7 years. That I mean, if let's say the other Faraid beneficiaries really need the money, the Sharia court or the educators that receive the distribution must actually hold the money for that particular person. If the person is male, then you need to calculate how much is the person due for their Faraid beneficiaries, hold it for 7 years, and then after 7 years, confirm by court that this person is pronounced dead. Therefore, then you start to distribute his Faraid beneficiaries to the eligible beneficiaries. Okay, I mean to just put the drama in the event that after 7 years he come back. Okay, so at least we have followed the right way, which is the court procedure and so on, and therefore there is no more clawback lah in that sense. Unless the family members like muafakat, like we discussed just now, they still have the money, they can actually return back the money if they want. But there's no obligation after that because we follow the procedure correctly.
Yeah. I think as long as the follow the procedure and legally follow, I think even though it's Faraid is still alive, it depends on the beneficiaries, their compassion, whether want to give back the lost estate, I would say, for the 7 years. So it depends because sometimes the beneficiary already use up the money, right? So depends on the compassion. Yeah.
Okay, thanks for the answer, even though the answer is not as dramatic as the question. Okay, next question. Ring of S. If have only mother or daughter, the inner circle will not be protected.
Yeah.
Inner
So I think
circle.
so I think the questioner understood the ring as that we discussed in our session.
Yeah.
So just want to recap. Uh, uh, there are 5 persons that Allah mentioned in Surah An-Nisa that these 5 persons must actually get from your estate distribution. Should you actually live to the final stage, which is the Faraid distribution. These are your father, mother, your son, daughter, and also your spouse. Okay. The moment the father and the sons are no longer around, therefore, this inner circle, the line has been broken, meaning that no one protect the line anymore. Okay. And because of that, then other person can actually get subject to their nearness to the family members. So as long as the father are still around, no matter how old the father is, okay, no matter how young the son is, it can be as young as 1 month or even few days, yeah. As long as these 2 persons are still around, and also son of son lah. If son no longer around, son of son is around, cucu is still around. Therefore, the inner circle is protected. If not, then other persons start to come in. If we understand the whole concept of inner circle and outer circle here.
Yeah. So my answer is that because when encounter this type of family structure for myself, this they need to do is estate planning. They are one of the most. They are one of, I would say, few family structures that need to do estate planning. Estate planning in the sense that you need to identify what assets you want to give to your daughter, what assets you want to do hibah or nuzria, what assets are you going to nominate for your daughter, because you know that in terms of your ring of heirs, you involves the daughter's uncles. Okay, we assume that both the daughter both the left the mother and daughter, so left the parents of the deceased pass away, let's say a husband, then left a wife and a daughter. This is a classic case I would say have to do in estate planning. Yeah. So I ever advise one case, this case, yeah. So until the wife, because she knows that the siblings of the deceased, the husband, her husband, the uncles of her daughter is not responsible. She knows that because she told me that they still stay safe. I mean, stay in Singapore, but quite far in Jurong. So she was in the east. So until in the wills, the state one ustad as executor, another sister of the ustad as executor, because that's how going, because he's trusted the outsider more than the family members. That's how I would say, that's why the case is quite unique, quite crucial lah, because he believed that the uncles, if the estate fall on the uncle, so didn't do. So that's why my advice is that at least you a portion of some of your estate for the rightful heirs, for the uncles. So got one account, one particular asset is meant for this. When I advise them, the one particular asset is meant for this faraidh distribution for the uncles, so they won't feel left out. So this is how you do estate planning. Yeah, I hope you all understand, because there's no writing I can write. Yeah.
Pretty sure the audience will understand from your reply. Okay,
Okay.
we shall move on. The next two questions are somewhat related.
Yeah,
By
yeah,
him.
I agree with you. So you can mix the two questions.
Yeah. So the first part would be, can we do a will for faraid beneficiaries in in the case that so that the assets are distributed equally among the children? So for the second part, if the will for faraid beneficiaries is already made and the person who made the will has passed on, how do we execute this will?
Thank you so much for the question. So this is a classic example where Muslim try to do a non-Muslim will or type of conventional will. So for Muslim will, as we discussed just now, you cannot give to your faraid beneficiaries. So your biological children are definitely your faraid beneficiaries, right? So therefore, in the eye of court, this is considered invalid will, and therefore is as good as you don't do any wasiat. Okay, because court deemed this as invalidated in the court, and therefore is as good as you don't do wasiat. Having said that, if the faraid beneficiaries go to the court, of course with the help of the lawyer, and says that okay, we understand that we cannot receive a portion or a gift from via this will, but we want the educator to be respected by court, meaning that can the court still actually allow the educator to be the person appointed in the will writing? Okay, if that's the case, and if everyone is in agreement, court can actually grant the person as the person appointed as an educator only, but still the distribution is still faraid, okay, as a faraid distribution, and whatever will mentioned inside that will writing, the gift will not be implemented. I hope you can understand. So the will is invalid, but because the faraid beneficiaries agree, okay, we can still actually go to the court and make the person as an executor. So at least that person can liquidate the assets and so on. Yeah. So court can actually grant that process as well.
Yeah. So I want to add in, I think it's a good answer by Ustaz Arun. So I want to add to the fact that if court is agreeable to elect the executor, so I think a lot of people always think of distribution. So a lot of people didn't think about the unlocking of the asset. If if you have this type of will where already have faraidh beneficiaries already made up, maybe they made into like conventional will, try not to dispute in terms of the who's going to execute the will. If it's trusted executor among the family members, then just follow through. Because if there's still fighting among who going to be administrator, going to be executor, I think it will drag on maybe 1 year or 2 years, and then you can't unlock the asset. So it will actually hurt the beneficiary itself. So I think this is another point need to consider. But in terms of the valid will, like Ustaz Arun says, is correct. So I think still goes back to AMLA. The only thing why I don't know why the will is done, the conventional will. Yeah, that's all.
Okay. Since we are in the topic of will, we shall jump to the subsequent question first. Okay, for the two witness, in terms of will structuring in local context, what is deemed for them to be adil?
Right. I think we have answered this question.
Yeah.
When it comes to two witnesses of the will writing, in Singapore, anyone can be a witness. Of course, that person must be at least sound mind and so on lah. Yeah, and trustworthy as well. Because at the end of the day, if there is a dispute, court will actually call these two witnesses. Yeah. So in local context, that is considered adil already lah, right? But from a fake point of view or Islamic jurisprudence point of view, there are other criteria. But the question is about local context, right? I think I should stop there.
Yeah.
Okay. Nothing else to add.
Okay. So we go back to the earlier question. Okay, daughter can take 2/3 of the inheritance. What about the other 1/3? Who can take it if there is no father or mother around? Or can you will it to the daughters?
So the answer will be not daughter can take 2/3, daughters. It has to be plural. It has to be more than 2 daughters. Then the faraid provision is the 2 or more daughters will get 2/3 of the inheritance. Okay, so if 1 daughter is only half or 50%, 2 or more daughters, then the 2 but provided there is no son. Okay, so this is the faraid permutations lah, like Khairuddin mentioned. A different family has different family trees, different situation. So in this case, if we subject our discussion on this only, it has to be 2 or more daughters, then yes, they get 2/3. What is the remaining of the 1/3? The 1/3 you can't give via will writing. Okay, it will be invalidated in the court. Okay, so the 1/3, if there is no more father, no more mother, then it will go to the deceased siblings. Okay, depending on if a father passed away, the father's sibling. If the mother who actually passed away, then it goes to the mother's sibling. Okay, the remaining of 1/3. And that if you don't have siblings, that's where the uncle come into picture and so on, nephew from the father's side and so on. Yeah, and last but not least, if you can't, there is no other person to receive it, in Shafi'i Mazhab, there is a Baitul Mal, the last resort or last beneficiaries, yeah, to receive the inheritance.
Brother Kai, any inputs?
I think I want to answer the other part. The beneficiary is not responsible. Yeah.
And the next question lah.
Okay.
The next question.
Okay. If are not responsible but give 1%, does this mean even if we put all wealth in Hibah, do we still need to allocate 1% of it to faraid beneficiaries?
Okay, based on my experience and my advice so far, I wouldn't say exactly 1%. It depends on the testator, the one who want to write the will, want to do the estate planning. But normally, I will tell them to apportion, because they must remember that whatever, if they feel that their beneficiaries are not responsible, part of it already, let's say the example is the one with the mother and daughter left behind, and then there's not happy with the siblings. So so even then the lady didn't actually put 1%, more than 1%. Yeah, because we always think, I think how Sarun can explain that. I mean, sangka baik that Allah will change their mind, Allah will change their heart. So when we do this in the future, that whatever apportion we already made for our rightful heirs or rightful beneficiaries, we bless our souls, and we bless our family. So normally I don't ever giving also one. I mean don't ever giving less. Actually try to give more. I mean when do estate planning, but you, because you must realize that your daughter also one of your rightful beneficiaries. Let's say you portion a certain account or a certain asset for your daughter, rightful beneficiaries, which include your daughter. So your daughter also gain after you apportion some of the another majority of your asset to your daughter. Something that we've done some estate planning. Yeah, maybe Ustaz I want to add about the, the whole thing concept of leaving behind. Yeah,
Yeah.
for this
Yeah.
question.
I think Karen has sum up a very good discussion here, so that we have to be answerable in front of Allah, right? So if our intention is to provide the welfare of the family members, like daughters, like our parents, and so on, then of course you can give more to that faraidh beneficiaries or your next of kin, and give less to other not responsible person. Yeah, if the intention is clear. But if the intention is to do injustices to other faraidh beneficiaries, like you give 1% just to show that your dissatisfaction to your other faraidh beneficiaries, then your intention is not clear. Okay, your intention is just to make to go against faraidh, because Allah says that you need to provide something to that faraidh beneficiaries. So we'll be answerable in front of Allah. But if the intention is clear, then I don't see any issues. If let's say you want to give 99% to the rightful beneficiaries who are in need, and then just leave it 1% to the not responsible person. Only you and you understand your family situation. Even ustaz or financial advisors, we can give based on the situation that we see. By the end of the day, you are the one who are having the conversation. The guideline is that as long as you don't do injustices to your foreign beneficiaries, I think that should be fine. Inshallah.
Okay, so
Sure.
in that respect, the bottom question is also on on similar the part on the beneficiary not being responsible about wasting money. So I would presume that both of your answers would be somewhat similar to the question on beneficiary not being responsible.
Yeah, I will answer the same. Yeah, thanks so much Zul for highlighting that.
Yeah, almost the same lah. That means the insurance, if you Awara dad's mother is an ongoing thing with us. So you can do estate planning in terms for insurance policy. Maybe give more to certain beneficiaries, your waris. Yeah.
Okay. Oh, it's been an hour and we've come to the last question. Time flies.
Oh, so it's the last question.
Yeah, so,
Alhamdulillah.
okay, last question. My father passed away 6 months ago. Just released his insurance money with him, nominated mother as the beneficiary, 100%. However, it eventually went to Faraid.
Hmm.
This
Yeah,
company.
company.
Okay, this part I think what I know is that, let's say mentioned by Ustaz, a group insurance company. Normally, the owner is the company. So the beneficiary is the employee. So any payout is to the employee. So they already mentioned the insurance is actually to the estate of the deceased. So when you go to estate to deceased, you need to be faraid because it's
faraid.
not actually. Yes, yes. Yeah,
Yeah.
normally group insurance, whatever payout received from the company is to the estate of the deceased.
Yeah, I agree with Khairuddin. I think it's very difficult for the group company insurance to nominate one by one, right, of the family members.
Yeah.
Imagine if you have 100 employee and times by 10 family members, so it will be endless
Logistic,
percentage.
administrative nightmare.
Yes, yes, yes. But again, if let's say the person who asked this question really can show that, yeah, actually there
Ah,
is a nomination, because he or she mentioned that there is a nomination to the mother. I'm not sure by right it shouldn't. I mean, there shouldn't be any nomination, like as Khairuddin mentioned. But we
yeah,
can
because I
also
handle group
check.
insurance.
Yeah.
So when I do group insurance, I got yeah lah, you know so many employees. So actually we don't have because the concept is the policy holder is the company. That's why it's group insurance. So any payout goes to the employee straight. So the employee pass away is called the estate of the
Estate.
employee. Yeah, estate. So that's why I think maybe he can. I don't know. I'm not too sure whether he's confused or what. I'm not too sure. Yeah.
Possible.
Can check
Yeah.
again. No worries. Just check again.
Okay,
So,
okay again lah. Yeah, maybe there's some different type of insurance. I'm not too sure hold by the company. Maybe because like Ustaz Arun mentioned, the employee didn't pay the premium for group insurance, right? Didn't
Yeah.
pay the premium. Yeah, it's a gift from the company. Yeah, like but what I did with group insurance, the employee didn't pay any premium. So unless maybe the company itself ask the employee to pay on the premium himself, something like that, through paying the give him some increment in salary. Not too sure. Maybe I'm not too sure. Yeah, means the holder individual. Yeah, something like that. Right, Harun.
yeah.
Maybe yeah. Some company what they did is that they bought first under the company name and then they assign back to the employee. Then the employee become the holder of the insurance policy. Maybe it's like that.
That
Have to
could be yeah, another type, meaning it's portable, and then yeah, the employee now owns the
own the policy.
insurance. Right? Yeah,
Yeah, own the insurance. Yeah.
so if that's the case, then you should in and the person has done nomination, it shouldn't go to Faraid. It should go to the
Yeah,
nominee.
yeah.
Yeah.
Yeah. Have to check the original policy structure. That's all. Have to check.
Okay. Okay. Since we've come to the end of the Q&A session, thanks again to Ustaz Harun and Brother Khairuddin to painstakingly answer our audience questions. Thank you.
Yeah,
Okay,
thank
thank
you.
you. It's a pleasure. So, yeah,
Yeah, I think
to
it's a
share
pleasure
the knowledge.
also.
Yeah.